Autumn Kiefer attempted to prepare a pre-sentence report in this case, but the defendant was very reticent to provide much information. So her report is somewhat abbreviated. I'm not sure if she's back yet. She's been on vacation. All right, it's 10:37. We're close enough to on time. This is the sentencing in a matter of People versus Brandon Bartell Schoolcraft. File number is 24649SM. Mr. Schoolcraft was charged with aggravated domestic assault, and the matter was tried as a bench trial before this court earlier this late summer. The defendant was found guilty by the court, and the matter was set for sentencing today. The court had requested a pre-sentence investigation because still had a lot of unknown quantities here. Attorney James Mequio, Special Assistant Prosecuting Attorney for St. Joseph County, is present with us on the Zoom feed. Mr. Mequio tried this case on behalf of the prosecution. John Bush represented the defendant at the trial. Since then, the defendant has retained attorney Anastasi Marcu, who is here with us in court this morning. Also present is Autumn Kiefer, who attempted to do a pre-sentence report, got only so far, and our complainant Leslie Schoolcraft is present, and the victim advocate from the prosecutor's office is present. As I indicated, even though I heard this case at trial, I still had a lot of unanswered questions about the defendant and this whole circumstance. So I asked for the pre-sentence. The defendant had retained Mr. Marcu, and there was discussion of an appeal or something. So he was reticent to provide much information. So good morning, Mr. Marcu. I'll start with you.
Good morning, Your Honor.
What's your position here?
Your Honor, is the court asking for allocution or is the court?
Yeah, no, allocution.
Thank you, Your Honor. So, the court and Mr. Mequio understand, I advised Mr. Schoolcraft not to speak at all about the substance of the offense. I did not advise him not to speak about his personal background or anything like that. But because he has a fundamental right to appeal a case if he chooses to do so, that was my safe recommendation to him to make sure that he preserved any rights that he might have had. Regarding any possible sentencing in this case, this court knows that I was not present for the trial, so I cannot speak about the facts that were elicited at trial. However, as to Mr. Schoolcraft himself, the court can see that while he did have a criminal history when he was younger, the last substantive offense would have been in 2009. That's now 15 years ago that he had any sort of either felony or misdemeanor behavior. That's a long time in which he has demonstrated a change in his behavior. All the other criminal offenses all occurred before his age of 24 when he was a young man, probably doing things that he shouldn't have been doing. Some of them were actually when he was a teenager. So I would ask the court to consider that because his last offense is at least 15 years ago, that the court consider that in fashioning any type of sentence. Mr. Schoolcraft has also been employed 11 years. Any type of substantial incarceration would most likely result in him losing his job. While he could take some personal leave, I don't think there would be enough personal leave available for a 93-day jail sentence for him to be able to maintain his job. Having a job for 11 years is a substantial positive. This court can weigh that against what the court heard at trial to decide how that affects the court's sentencing in this. What I'm asking the court to do is to consider instead a short jail sentence, 14 days or less, with the term of probation of 1 year, to make sure that he is complying with the law. If any domestic violence counseling is recommended, I know he'll do everything that he's supposed to do. The court can see that even when he was young, he was able to at least on at least one occasion be able to successfully complete his probation. Now that he's a mature adult, He knows what his responsibilities are. If the court tells him to be somewhere, he'll do it. If the court tells him to do an assessment, he'll do it. If the court tells him to complete counseling, he'll do it. He'll do whatever the court tells him to do. So my main 2 points are, he's been crime-free for 15 years. He's been able to be a contributing member of society for that time period. He's had a great job for 11 years. I just don't want him to lose that, Your Honor, and that's what I'd ask the court to consider.
Thank you. Mr. McWheel, before we hear from you, I'd like to hear from the defendant, and then I'd like to hear from the complainant, and I'll give you a chance to speak. Mr. Schoolcraft, what do you want to tell me, if anything?
I really don't know. I'm just, there's so much stuff that you didn't hear. I don't know. I'm just trying to,
Let me ask you a couple of questions. You're still at a,
yes,
what shift are you on?
second.
Where are you living?
Currently I'm living in my truck. I am staying, like, sometimes I can stay like my aunts or friends and things like that, but mostly I'm in my truck.
Where's your aunts?
3 Rivers.
Are you contributing to the family expenses?
What do you mean?
Your house payment, food for your kids, the light, heat bill, that sort of thing?
I mean, I'm paying $403 a week in child support.
All right, so there's a child support order in effect.
Yes.
When did that take place?
I believe in July.
But you're not yet divorced, correct?
No.
All right, so there's an interim support order.
Yes.
All right, well, that's something. Are you working overtime?
When I can. It just depends. Some weeks I can get Saturday, Sunday. Some days I can stay over. Just it's up and down.
So you take all the overtime you can get?
Yeah.
All right, Ms. Schoolcraft, would you come forward, please? Thank you. You're Leslie Schoolcraft?
I'm Leslie Ann.
Yes, you told me that, and I apologize, I
That's
forgot.
okay.
Let me change that. You were here at the trial, and I heard your version, and I heard your version, and I believed yours. I believed Leslie's version over Brandon's version, which essentially means I didn't believe Brandon was telling me the truth about what happened. As Mr. Marcoux indicated, he's working at $403 a week in support. You got kids with special needs. I don't know, frankly, how you do it. You're working, you've got children that need extra help. I don't know, there are enough hours in the day to do everything you do and sleep. But it used to be for both of you. Now you're carrying most of that burden yourself. What would you like me to know?
I did write a statement.
All right.
Your Honor, I would like to address the courts today because speaking to Brandon won't matter to him. Honestly, he doesn't care. I've tried many times since trial and he has never taken accountability for assaulting me since it has happened. He's shown zero remorse. He's never felt bad for what he's done. He's upset that I stood up to him and stopped allowing him to hurt me for the first time. After he attacked me that day, he ran from our home. He showed up the next day for his belongings. I gave him even more money, packed all of his belongings in his truck before he arrived, gave him a hug while he was completely disrespectful to me in front of the officers. He then left out of state for 4 days. He had no contact with me and his disabled children. He did not check to see if the kids were okay after having to witness their mother be attacked. He never asked if I was okay or needed medical treatment. He just moved on with his life and has told everybody lies about what has happened. He has sat here during trial and he never looked up for him from his phone while he was texting. Unless he wanted to tell his attorney something. This case has been a joke to him. It's been how to beat this case and how to hurt me and our kids. I've been through so much already with the tragedy of losing my daughter in an automobile accident in April 2020, where my daughter burned alive when she came out of the covered bridge. I won't sit here today and say he hit me and knocked me unconscious and broke my tooth, because I could care less about what he has done to me. Your Honor, I didn't lose anything that day. I actually got my freedom back. My daughter, my granddaughter, will look down from heaven and not have to see me being treated this way anymore. When I look back at the day, I'm severely traumatized. I have panic attacks and I now shake uncontrollably, thinking about being around him again. The damage he has caused our children is what makes me have panic attacks and cry uncontrollably. And not able to sleep at night about what's coming next. What has happened because of the events that happened on March 26th, Brandon has realized that he can't hurt Mia anymore unless he hurts our children. So if he doesn't care enough about the traumas that he has caused our children because of this day, he definitely does not care about what he has put me through. What has happened since this day when he attacked me in March is he has continued to do things to try to hurt me. He's came after my job and caused issues with me with my employment. He's came to my home and threatened me to the point where I had to file for a PPO so that my kids had a safe place and he wasn't able to come to my property any longer. He worked 12-hour days so that he could stay after work until 10 a.m. to work over on my shift. He would then wait in the parking lot until 2 p.m. when I left work. And he would leave after I left so he could keep tabs on me. I had to call the prosecutor to get him to stop. That's when he started claiming that he lives in his truck in the parking lot. He has met me 4 times since August, but refuses if the kids are around. This is a way for Brandon to control me. He will tell lie after lie to get away with the things he has done. But Your Honor, he's not hurting me. He's hurting our kids. I won't sit here and say I want him locked up. I won't say he deserves this or that, because that will only make him hurt our kids more. What I will say is I don't want him to lose his job. I don't want him to suffer at all for this. I do hope that he gets counseling and anger management, whether that's on his own or through the courts. He has a major issue with his anger. His anger gets worse when he drinks and eats edibles, and he takes his anger out on me and the kids. I don't wish bad on him at all. I hope that one day he finds peace and he stops trying to punish me and the kids. Brandon, today is a clean slate. Now it's your choice where we go from here. Hopefully it's forward and moving up, because we've always been a team. We're better than this, and most of our kids deserve better than this. I hope you get the help you need.
Has he seen the kids?
Very rarely.
He
told me that he can't see the kids unless I drop the PPO. So I dropped the PPO so that he can see the kids. And he's met up with me 4 times at work, but won't see the kids.
All right, so you've got 2 autistic children that you're raising by yourself, putting to bed, getting up in the morning, dressing, getting ready for what they have to do during the day. You're doing all that by yourself. He's not involved, obviously, in any of that.
He works second shift, so now I begged him to come to first shift. He told me he couldn't miss the PPO. I dropped the PPO so he could come to first shift so he could see his kids. And nothing is good enough. Nothing that I try is good enough. I even sat in my truck a week ago when my son had to have emergency surgery so that he could be there. And I barely got updates. The one thing I asked for was, can you at least tell me how long surgery is going to take? And I wasn't even allowed that.
Now, there was a strange dynamic of he had a female friend who wanted to meet your children, was or was not a girlfriend. I'm not real clear on what that relationship was. Is that person still in the picture?
Yes.
So he has a female friend who may or may not be his girlfriend.
Yes, but I don't think she wanted to meet the children. I think that they were just at the house so that they could spend time together.
Yes, your allegation that they would come to your house while you were at work.
Yes.
So your contention is he gets out of work at 10 and sleeps in the parking lot until you get,
Well, he's on a different shift now. That's what he was doing up until, I think it was, 8-5, he switched shifts. And went to second shift. But before that, when he was on third shift, he would stay over until 10 a.m. so that he worked halfway through my shift. And then he would stay in the parking lot until 2 when I left, and he would leave the parking lot about 2:20. And then he would go back to her house in Sturgis and then do it again the next day.
her house being the
The
other,
girl.
okay. Also, I'm very sorry. If I knew the Bingaman girl was your daughter, I'm very sorry. Are you the one that keeps up that little memorial there?
It was both me and Brandon until he left, and now it's me.
Was it his daughter also?
No.
I drive past that every night on the way home to work. And I remember it was bad, but I smile at the fact that somebody is maintaining that for her memory. I thought, well, her family must have loved her. I didn't realize it was you and you. So I'm sorry for your loss. Yeah, I see it every night. And it's always well maintained and updated. And so you got that burden also. He was talking to you about dropping the PPO, which in and of itself is a violation of the PPO, but PPO has been dropped. People often stop me in the store or they say, hey, I watch your channel. Thank you. But you need to throw the book at these people. You're too soft on everybody. I get that a lot. There is a statute in Michigan that says there's a presumption that there won't be any jail. Fine and costs only. There won't even be a probation, but this case certainly overcomes that presumption. There's an underlying issue here about the defendant's employment. He isn't going to get a prize for Dad of the Year right now, but he is paying $403 a week in child support, which would go away.
He does pay his child support. He does pay his child support.
As well as the benefits that he has. Mr. Mequio, you were here. You presented the people's case. What's your position here?
The court has heard the testimony, so I'm not going to revisit any of the trial. As the court knows, there are varying degrees of domestic violence, from maybe just a shove or grabbing a cell phone to what we have here, where we have a physical injury. One of the things I remember from this trial is the exhibits with the blood stain on the carpeting, which was fairly significant, which to me showed that there was some pretty extreme violence that was used in this case. I know the probation officer was limited on the information and isn't recommending probation, but given what I've heard from the victim and also the possibility of substance abuse issues, I believe that a significant time of probation with some at least conditions involving counseling and perhaps anger management and perhaps family counseling, and certainly substance abuse issues should be dealt with. I would recommend, Your Honor, a reasonable length of probation, 1 year at a minimum, I think, perhaps a little longer, given what the counseling efforts may need. The victim doesn't want the defendant to lose his job, and I think that makes sense. If it wasn't for that, I think I would be asking for a significant amount of jail time, but I'm going to leave that to the court's discretion, hoping the court can fashion a remedy that will punish him, but also allow for some rehabilitation, and most importantly, give him the ability to continue to support his children.
Do you believe he's actually living with this female friend?
I do believe he's staying with his aunt most of the time, but then I do believe he stays with her. I don't really care where he stays. He can live wherever he wants. But I do care if
something needs to be better than living in your truck.
if he is put on probation and there's a no contact with me, then he won't see my kids. I want him to see my kids.
So you don't want a no contact order?
I want my kids to be able to see him. My 7-year-old is struggling really bad.
Well, for example, if the divorce were amicable, he would
He can
have,
have whatever he wants.
he could have, you'd get a weekend off. You're on duty 24 hours a day, 7 days a week.
There's things that you guys don't know that I can't say. I'm sure that
All right.
prevent it. It has to be supervised.
All right. And at some point, maybe we'll get to that point.
Your Honor, it's my understanding that both of them have family law attorneys. And the hope is, as the court knows, when things like this happen, it may take a little while for things to kind of normalize. But I know that Brandon wants to be able to see his children and to be able to be the parent that I think the mother wants him to be. It's just going to take a little bit of time for that to happen. And I think both of them should be patient with it.
I also can't punish a 7-year-old. My 7-year-old can't keep waiting for his dad.
Well, the kids don't understand, and they wonder, what did I do wrong that my dad doesn't want to see me? And there's nothing good about it. As I mentioned, there were several weird side stories to this case that never were resolved. The cans of alcohol in the sink, the fact that everybody's asleep in the middle of the day in a pitch dark house, this friend that's not a girlfriend, the fact that he allegedly walked to Kalamazoo in the middle of the night in March. His version versus your version, and as indicated, I believe the complainant's version. So I believe that he didn't tell me the truth about what happened. And I don't believe he's remorseful. You regret the whole thing that you're here, but you haven't owned any of this. Ms. Kiefer made a recommendation of 93 days, I think maybe a little bit out of frustration. Mr. Marco explained why I wouldn't let him talk to you. Anything else to add on him?
Well, unfortunately, like I said, I wasn't able to talk to Mr. Schoolcraft and get a full report completed as I would have hoped. I did read the police report prior to my interview that was supposed to happen with Mr. Schoolcraft, and learning here today the things that I've heard from Leslie Ann. He needs a probation. We're not out for someone to lose their jobs, but this is a severe offense. There was a lot that happened. So I believe that there should be jail included, whether that be work release, and we give him time to get that paperwork back to Twin County, and he do that and work at the same time. But I would recommend that if he's on a probation, it would be a 24-month probation. He would do the full 2 years, the 26-week domestic violence group, substance abuse assessment, random testing. As Leslie Ann has just stated to me, she wants a no contact in this case because of the children. Obviously, this court can't enforce that parenting time, but we can make sure that if they do have contact, that there isn't any assaultive or threatening behavior during that time. But I do believe that there should be some jail in place on top of the probation.
All right. I am going to go with a 24-month probation because the defendant's successful at it. He's entitled to have the probation discharged after 12 months. If I did a 12-month probation, he could theoretically be entitled to discharge after 6 months. I agree with Ms. Kiefer. He needs the full domestic violence treatment class, not anger management. That's something less significant. He needs the domestic violence full class. He's not eligible for a deferral because he has a previous conviction. but he could benefit from the class, both as a parent and in your divorce. Mr. Schoolcraft, if you successfully complete the domestic violence class, A, it'll make you a better person. B, it will impress Judge Pattison that you may be somebody worthy of visitation and maybe even part-time custody. I'm gonna order 93 days jail, credit 1. That means there's 92 days left to serve. I could do it several different ways. I could do it 92 days flat. I could do work release, which I'm a little reluctant to do because it's more expense. It's sort of 6 of one, half dozen of the other, or weekends. Weekends takes away his ability to do overtime, but it maintains his job. So I'm going to do 93 days in jail. Of the 93 days, 78 are deferred, which means there's 14 days to do on weekends. And if they'll accept a work release for 14 days, I would allow it. But you're going to miss most of the football season because you're going to be in jail every weekend for 7 weeks. To think about this, the fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $960 probation oversight fee, and to pay for the class. I am ordering the full domestic violence class, substance abuse evaluation, no drugs and no alcohol. And testing as demand also means you can't use marijuana. You got gummies or vapes or whatever may help you get through life. But while you're on this probation, you're going to be clean, which will also impress the judge in your divorce case. Mr. Marcoux, I left this up. The bench trial is on, at least I thought it was. Maybe I deleted it. I let things run for about 30 days and then I remove them. Although I think maybe I took this down by mistake. So you could have watched it. But nonetheless, I made the finding that I did, and I stand by it. You're going to do the full domestic violence class, which right now sounds like that really sucks. However, it doesn't suck, and I think you're going to get some benefit out of it. There's a bunch of issues, as your wife said and you said. There's stuff going on that you can't tell me, and I don't know why you can't tell me, but I am aware there's stuff I don't know. She wants you to be a parent to your kids. She's not going to be in a relationship anymore, or you moved on, but her life is really hard, and it's no picnic living in your truck. So you're going to have to get a permanent residence. We're not going to have an address of a license plate number. Anyway, that's my order. I want you to go downstairs to the probation department, and they will get you plugged into this. We'll set up the testing, which will be random, and the treatment, which will be beneficial, and when you're going to serve your weekends in jail.
The court gave them the option of 14 days work release if they're allowed to do that, correct?
I don't know if they'll take a 14-day work release.
I don't know if they will either, but I
Generally,
think
in
it's
order to
worth
do
them
work release, you
explore.
have to do at least 30 days.
Have him come in and work on Saturdays, and it could be part of his employment, and I know he.
Well, then he'd have to do 1 day at a time. So it'll be.
So he can work around this, right?
Yes.
Okay, you'll do it, right? Okay, all right. Good.
All right, Ms. Kiefer, thank you for your help here. Good luck to you. I'll think about you every night when I drive home.